All right, 7:16. Whew. I've been driving along. Okay, anyways, I don't want to sing because I can't sing. The okay, so we were just talking about um, the how land was transferred in common law to now we're starting to explain how things were transferred um, from the common law once the legal title was set into the fiafis, who then created the beneficial interest for the previous legal title owner who come in as beneficiary, and now he is relegated to put trust in these fiafis to do his bidding as he has the outline in the original agreement to create the trust. But not all things, and this is what separates now, as before we start getting into the era of William King Henry VIII and the Statute of Uses 1535, where we start to see how the use and the trust are segregated, even though the trust was a foundational principle of, the use was a foundational principle of the trust, and now we commingle those two. There actually is a separation of what that means, and it's very, we got to look at each one of those things, and again, that's why we're sort of going in a syllogistic approach here, so we can see if, well, if this is correct, and we have to look at, then that must be correct, and we have some way to make sure that we keep with the truth through measurements of how we got there. And if I go off base, I need to know. I don't know. Sometimes I might slip off my as my buddy likes to say, my cheese slides off the cracker. I've lost it. Okay, the main substance. So this is a way to make sure that we have checks and balances. That's a better word of saying it. That if we move along here, that each one is going to support the other thing that's said before. Okay, so we said that the person who has the use, in this case, legal title, it's called a cesspool use. Who are the fiafis? People whom owe trust. He has a competence. What is a competence? It's trust. And most medieval uses were passive. The fiafis didn't manage the property, meaning, just like I explained how to livery assaission, the fiafi was just used as a third party to witness the transfer of land, that legal title, into the new person who now gained possession. Statute of Richard III, Chapter 1, 1484, allows the cesspool use to make a fiafment of the land even without concurrence of the fiafis. Wow, here we go. Very important. The Statute of Richard III, Chapter 1, the cesspool use to make a fiafment to the land without the occurrence of fiafis. So you know what? I don't even really like the way that's said, and I know it's Harvard. How he's saying it doesn't roll off as effectively as what I think needs to be unpacked from that. How can we say that differently? What Statute of Richard III, what happened was that Richard III at this time was a fiafi himself. He held a lot of lands that people trusted him with. He was that trustworthy type of dude, I guess. And he held lands personally as an individual, as the only individual for the benefit of another, but he also held lands with others. Just like I've said, you can have up to 13 or so fiafis, to which he was part of that group as well. So he had a bunch of different interests. But at that time, when he became king, or he was the right to the heir of the throne, a king cannot be a fiafi to anyone. Okay, he has to run. He's absolute. He's close at that time too. He was held to common law. He was absolute, so he could not be a fiafi to anyone. He already had a duty and power. They don't commingle. So, in order for him to get the rights to that throne, he had to give up all of those interests he held a fiafi. So, what he had to do was transfer what he had and gave it to the beneficial user. And you see what happened there? It was the first time, well, maybe it happened a couple of times, but it was the first time under law that was recognized that the one who had the beneficial, the equitable title, held both beneficial and the legal title at that time. There you go. And that's what we'll divest into as we get into tenant for life, because that's what a tenant for life is, who holds both of those at that time. Even though the title's split, common law holds legal, equity holds, or equitable title has equity. At that moment, he made a statute that as soon as he released that duty of being a singular fiat for that interest of the use, he gave it to that person who held the original title that then was transferred into Richard III as fiat, to which then came in as a beneficiary. He just went and said, well, you transferred from A to B back to A, which you couldn't do before. So he was the first one, or I think the first one to do that, or it was made under statute, or he made it that if you allow the fiat fee, which were those groups of fiat fees, he couldn't expunge their rights. So he then made it, as it was already, that now that's a trust. See, now it's, there it is. That's the separation between the true use and the trust. Trust is when there's trustee's duties and the use predominantly was without a trustee. That the use now was either A, held in another, but then after statute, as we're learning here, it moved in to that person who held singularly the beneficial interest. And now that individual now held both. It was up to him to deal with it, how he saw fit. So if he wanted to transfer that back to circumvent the common law, he would have to give it to a new trustee. See? That's how it worked. And you see, you can't destroy either one without destroying a lot of other set of laws that happen in order to secure those interests. And lawyers were making hand over fist at that time because there was a lot of confusion when people were continuing to make titles upon titles. Everyone that got a title, well, I'll make a new title and I'll split this, and no one knew who was on first, on second, what's on second. Well, yeah, but can still a routine and forget it. But anyways, that's when the lawyers started making all the money. They're making hands over the fist because they had to go and try to, before you even buy the title, or if you bought a title, you had to go to a lawyer to find out and trace who's got this. Then if you had, what could it be usurped if it's not a powerful? There was so much. The lawyers were making piles of money, and they were also part of Parliament as well. So you can see they were starting to amass more and more power. And today, you can't even do anything within the system without a lawyer. There's nothing that you're touching or doing anything. It doesn't matter your food, anything that the lawyer has not touched first. They got ultimate power in this system, but they have no power in common law, guys. Get that? Isn't that great? Okay. I digress there, but you see how that happens? So hopefully I unpack that better. If consideration was not attached to the conveyance, we're still reading Harvard here. If consideration was not attached to the conveyance, or if consideration was made into a fiat fee, but the conveyance was not executed, the law recognized this act as a use. If it recognized that there was not a consideration attached, like we said, liberalization, or if the land did not get transferred, even though it was paid for, but it got transferred to the beneficiary, or if it was held in fiat fees, then that was, or it wasn't held in fiat fees, sorry, backtrack that. If it wasn't held in fiat fees, that was considered a use, the land. Because a trust, there has to be a trustee, and the legal titles have to be held. It's pretty simple to get that straight. The use, again, to get through our minds here, there's a lot of information here, is that if there's consideration made, then it was still a use. If the consideration was made but never got transferred to the beneficial interest, that was a use. And if there was no trust whereby the land was held, both titles were held in a single person, that was recognized as a use, not a trust. Okay? All right. Okay. Going into jurisdiction, perfect. 10 minutes. Bingo.